Sharon Buccino is a senior attorney at the National Resources Defense Council in the U.S. She represented the NRDC in the successful 2019 appellate court challenge of the FCC's 5G rules that preempted the NEPA requirements for local government environmental impact assessments of cell antenna permits.
Good morning. My name is Sharon Buccino. I work as a senior attorney for a national environmental organization, the Natural Resources Defense Council. This session is designed to provide an overview of some of the key legal principles that affect the authorization of wireless services and the construction of the networks needed to provide these services. The legal principles that I will discuss are involved in debates that are happening right now as telecom companies are seeking to expand their networks across the country. What is the extent of local control over siting new cell towers and other wireless infrastructure? Who is responsible for assessing the health and other environmental impacts of these towers and the wireless services they make possible? These are questions I hope you will better understand the answers to after spending the next 30 minutes together. Legal issues that I will not address but are relevant to EMF radiation include the potential liability for harm caused by cell phones and wireless infrastructure and labeling obligations for cell phones and other products using wireless technology. So let's jump in. As an environmental lawyer, I've traditionally worked with federal agencies like the Environmental Protection Agency and the Department of the Interior. But over the past 2 years, I have come to know the inner workings and the idiosyncrasies of the Federal Communications Commission. In the United States, it is the Federal Communications Commission that authorizes the use of the electromagnetic spectrum for the provision of wireless services. The management of the spectrum involves 4 basic steps. First is the allocation, the designation of a specific segment of the spectrum for a specific purpose. After that, the FCC issues service rules. These are the rules that spell out how companies can use a particular segment of the spectrum. And then third is an auction. The auction determines which company gets to use the specific segment. And finally, deployment, the construction of a network to use a specific segment of the spectrum. With the FCC's control of the spectrum comes responsibility, a responsibility that includes the duty to inform and protect the public from the health impacts of radio frequency radiation. The FCC's duty to inform and protect flows from 2 different federal laws, the National Environmental Policy Act, known as NEPA, and the Telecommunications Act. I will explain the requirements of each statute and what these requirements mean for medical providers or others working to limit the health impacts of EMF. Signed into law in 1970 by President Nixon, the National Environmental Policy Act, or NEPA, is intended to, and I quote, prevent or eliminate damage to the environment by focusing government and public attention on the environmental effects of a proposed agency action. NEPA requires federal agencies to analyze the environmental impacts of its proposed action and share these impacts with the public. The White House Council on Environmental Quality has issued regulations implementing NEPA. These regulations require that environmental information is available to public officials and citizens before decisions are made and before actions are taken. In addition to these CEQ regulations issued by the White House, each federal agency, like the Federal Communications Commission, issues its own NEPA procedures. If the proposed federal action may have a significant impact on the environment, the agency must prepare an environmental impact statement, or EIS. NEPA requires the agency to share a draft of its EIS with the public and respond to any comments that the public makes. If the agency does not think that the impacts are significant, it can issue a finding of no significant impact or use a categorical exclusion to comply with NEPA. NEPA defines environmental effects broadly. When analyzing environmental impacts, NEPA requires an agency to consider the natural and physical environment, but also the relationship of people with the environment. And so environmental effects includes ecological impacts, but it also includes health, social, and economic impacts. The FCC established its first radio frequency exposure guidelines in response to its obligations under NEPA. This occurred in 1985. The Commission recognized that it could not meet its obligations under NEPA to analyze the environmental impacts of its action authorizing use of the spectrum without understanding the potential biological effects of radio frequency radiation. As wireless communication expanded, Congress fundamentally changed the legal framework governing telecommunications when it enacted the Telecommunications Act of 1996. This was the first major revision of federal communications law since 1934. A main purpose of the act was to accelerate wireless communication. One way of doing so was by concentrating regulatory authority over the environmental effects of RF radiation in the FCC, the Federal Communications Commission. The act prohibits state and local regulation of wireless facilities based on, quote, environmental effects of radio frequency emissions, so long as the facilities comply with FCC regulations concerning such emissions. So the question that's coming up all across the country is what counts as environmental effects? What can local governments regulate and what can they not? As with NEPA, courts have interpreted the definition of environmental effects broadly under the Telecommunications Act. Local governments have been able to regulate certain aesthetic effects of cell towers and other wireless infrastructure, but run into challenges when trying to limit health or other environmental effects from wireless network construction. Given the limitations local governments have faced in regulating cell towers and other wireless infrastructure, what the FCC does and does not do to address environmental effects becomes critically important. This is not just an issue of federal versus local authority. While there are many federal agencies that could address health and environmental effects of EMF, Congress has concentrated power and responsibility in the Federal Communications Commission. The same year it passed the Telecommunications Act of 1996, Congress limited the role of the Environmental Protection Agency by eliminating EPA's funding for activities related to RF radiation. In passing EPA's appropriations bill that year, Congress specified that, and I quote, EPA shall not engage in EMF activities. Since 1996, EPA has not had a funded mandate to work on radio frequency matters. As EPA's website indicates, the agency's mission is to protect human health and the environment from ionizing radiation. EPA does not address non-ionizing radiation that is emitted by electrical devices such as radio transmitters or cell phones. Many of you may think that this is a mistake. I do. EPA is the agency with trained professionals that have expertise in health and environmental protection. The FCC does not have such expertise. The concentration of authority in the FCC was a congressional choice based on politics. Telecom companies had the ear of members of Congress and wanted a federal agency that they knew well and could influence in control of assessing and addressing the environmental effects of EMF. If we want to change that, we must marshal the political power to do so. This takes sharing your expertise and experience with your representatives in Congress. As medical professionals, you have evidence of harm that Congress needs to hear. But in the meantime, the FCC cannot ignore the responsibility it was given. With passage of the Telecommunications Act, the FCC has the duty to protect the public from environmental effects of RF radiation, in addition to informing the public about such effects. In other words, NEPA requires the FCC to understand the environmental impacts of its actions. The Telecommunications Act requires the Commission to limit these impacts. So what has the FCC done to comply with these requirements? Not much, unfortunately. The FCC revised its RF exposure guidelines in 1996, but despite growing evidence of harm beyond thermal effects, the FCC failed to address such non-thermal impacts in its guidelines. It stayed focused on thermal effects. The FCC also failed to address environmental effects on living beings beyond humans. Pressure continued to mount regarding the potential health and other environmental effects of EMF. Scientists participating in a federal interagency radio frequency work group repeatedly raised concerns with the adequacy of the standards. Congressional hearings were held in 2008 and 2009. Following a request from members of Congress, Henry Waxman, Anna Eshoo, Ed Markey, the General Accountability Office issued a report in 2012 concluding that exposure and testing requirements for mobile phones should be reassessed. In 2013, the FCC initiated a notice of inquiry into the adequacy of its exposure standards. For 6 years, the FCC failed to take action in response to the inquiry. Then, just about a year ago, in December 2019, the FCC terminated its inquiry. It terminated its inquiry into the adequacy of the 1996 guidelines. The Commission made no changes to the exposure limits that had been set over 20 years ago. A challenge to this termination order is now pending in federal court in Washington, D.C. A decision is likely, my best guess is in the next 6 to 9 months. NRDC filed a brief in that case. The main issue before the court is whether the FCC's decision was reasonable in light of the scientific evidence in the record. The FCC failed to respond to significant evidence in the record regarding non-thermal impacts, electromagnetic frequency radiation from wireless technologies can have on humans. Moreover, the FCC failed to address the impacts on non-human elements of the environment. Increasing evidence is showing that EMF causes harmful effects to birds, bees, and trees. Given the interconnected web of all life, we cannot afford to ignore these impacts. That is what Congress recognized when it passed the National Environmental Policy Act. The FCC has a legal obligation to look at these impacts. The role of bees as pollinators in the U.S. has an estimated economic value of over $15 billion. Globally, it is estimated that 35% of all crops are dependent on pollinators. However, the increased proliferation of wireless services and the increased radiation that comes with it may be contributing to the collapse of honeybee colonies. RF fields have had similar troubling effects on migratory bird species. Research suggests that EMF disrupts birds' orientation by disabling the avian compass, their ability to navigate. The Department of the Interior has criticized the FCC's RF exposure standards for failing to fulfill the responsibilities that all federal agencies have to protect migratory birds. Turning to plants, while research into the effects of EMF on plant life is limited, evidence exists for concern. One study indicates that mobile phone radiation can cause various abnormalities in plant cells. Yet, the FCC has plowed full steam ahead in paving the way for construction of new networks all across the country without looking at all at the effects of EMF on the non-human biological world. 2 years ago, in 2018, NRDC challenged a previous FCC order. In this previous order, the FCC sought to eliminate review of impacts of EMF on the environment as well as on cultural and historic resources, the impact of the construction of cell towers and other wireless infrastructure. 16 Indian nations joined NRDC in this lawsuit. The Federal Court of Appeals in the District of Columbia found that the FCC had acted in an arbitrary and capricious manner and invalidated the FCC's action. As a result, the FCC must still conduct environmental review under the National Environmental Policy Act. What does this mean in practice? First, the FCC cannot issue a license to use the electromagnetic spectrum without evaluating the environmental impacts of such use. The Commission will argue that it completed such assessment when it evaluated the adequacy of its RF exposure standards. The problem is the Commission didn't do its job in looking at the evidence before it. It is now for the courts to decide whether the Commission did or did not consider the evidence. After a company has a license to use the spectrum for wireless services, it must then construct a network to provide them. The FCC has a responsibility here as well. In my presentation, I've explained some of what the law says about the FCC's responsibility to inform and protect the public from health impacts of EMF. The FCC cannot ignore these impacts. The National Environmental Policy Act requires the FCC to evaluate the environmental effects, including the cumulative effects of the wireless services that it authorizes. The Telecommunications Act of 1996 imposed an additional duty on the FCC, the duty to protect. In stripping local governments of some of their authority over the environmental effects of electromagnetic fields, the Telecommunications Act imposed a responsibility on the FCC to set exposure standards sufficient to protect human health and the environment. The FCC has failed to meet these legal obligations. It will take lawyers and politics to deliver the information and the protection that these laws require. As medical professionals, you can help shape the politics that will deliver the protection federal law mandates. First, you can share your expertise and experience with elected officials, both locally and in Congress. And second, you can share your experience with the Federal Communications Commission, the commissioners, and the agency staff. A fundamental principle of our legal system is that agency decisions, like those by the FCC, must be reasonable. The decisions must be supported by evidence. When the FCC's decision conflicts with evidence in the record, a court will invalidate such decision. Medical professionals can provide critical evidence of the harm that individuals are suffering as the FCC makes new decisions shaping the deployment of wireless technology.